Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss the case titled as Common Cause, a Registered Society versus Union of India and others. This is case number 24 in the leading cases list of AOR exam. It is a 2008 Supreme Court judgment, and because we all know that has Common Cause as an NGO, as a registered society, has raised various issues times and again. Euthanasia case is also fought by Common Cause. This case is specifically dealing with traffic safety measures and Motor Vehicle Act. And Justice Markandeya Karju is sitting in the bench with Justice H.K. Seema. And here, what is happening? The Supreme Court is refraining from exercising judicial activism. It is exhibiting judicial restraint in this case. So let's delve into the facts of this case. What happens here? The petitioner comes to the Supreme Court and files a public interest litigation saying that the directions need to be given to authorities for taking various traffic safety measures to control the occurrence of road accidents. Okay, so the petitioner is saying that judiciary needs to interfere and judiciary needs to issue certain directions to road safety measures so that accidents can be prevented on road, efficient traffic management can be done, etc. Now judiciary here, the court here is restraining itself from getting into issuing directions, because the court says that if we come and if we start giving the directions, then that is going to be a fatal blow to separation of power, of course, because what is happening, we do already have Motor Vehicle Act, right? We do have Motor Vehicle Act, and we do have a competent act focusing on it. Now if I issue direction, if Supreme Court issues direction, it is infringing into executive or legislative function. So if the MV Act is an efficient act that monitors road control, that monitors traffic safety measures, but if Motor Vehicle Act controls that, but if Supreme Court is to interfere and Supreme Court is to fill the lacuna that might stand in the Motor Vehicle Act, it is going to be an abuse of the process. Okay, so the court here is emphasizing this one paragraph I had liked so much. So the court here is emphasizing that it is true that Article 14 and Article 21 can be expanded based on the pragmatism, based on the need of the hour, because our constitution is a dynamic document. Constitution is not a stagnant document. We interpret constitution as the need of the hour arises. But the tools that are given in the hand of judiciary in the ambit of Article 21, in the ambit of interpreting Article 14, cannot be used sparingly. It cannot be misused by the court so as to issue any kind of directive. Now in this case, the issuance of directive is not needed, okay, because there is a law on that. Legislature is taking account of that. Executive is taking control of that. Road safety is a measure. Public safety is a measure of public safety. It is in the hands of executive. It is in the hands of legislature to look into it. Judiciary is just monitoring how the law is being implemented, and we observe that because of Motor Vehicle Act, there are road control, road safety measures in action. Okay, so constitution here, it is written, constitution is not a brahmastra for the judiciary to justify any kind of or every kind of directive it issues. Okay, so it has been always well settled that all the writs cannot be issued by the court, and this was one kind of futile writ which the court could not justify in the name of judicial activism to issue certain directions, to interfere in the legislature or executive functions. And if even if this allegation is true, even if it is said that Motor Vehicle Act is sort of incompetent and executive and legislature are not performing their functions well, it even then does not justify that judiciary should take over the function of executive or legislature, because firstly that is going to be a violation of separation of power, and secondly, Supreme Court here is not sitting as an expertise not exhibiting expertise, and does not have a resources to say that what directions could be given for what area, because of course areas do matter, rural roads, urban roads, they are all different, right? So Supreme Court here is not having that expertise that it can make or issue directions in the law. Now what is happening here, if I take you, if this is a discussion that I personally want to have, because we did one case where we had Vishakha, where the Supreme Court has exhibited pro judicial activism, made guidelines because it was needed. And then there is one road safety case which is coming into picture, and judicial activism is not exercised here, rather uh, judicial restraint is in the picture, we can see. So what is happening in both the cases that personally I feel needs to be discussed is, when we talk of Vishakha, we do not have a competent legislature at that time. Okay, so in 1997 we only had CEDAW that we could refer to, Convention Against the Elimination of Discrimination Against Women, and we only had Article 14, 15 and 21. So in the ambit, the Supreme Court is issuing guidelines, it is issuing directives, because it is protecting the dignity, protecting the Article 21 rights for women at workplace. But here, when we talk of, activism in case of road safety, traffic control measures, what is happening? We do have a legislature in action. So Motor Vehicle Act comes back in 1988, and we are now having this case come up in 2008. So we do have an act already in place. We do have executive measures in place. We do have traffic control measures in place. The legislature has taken account of the action. So this power that is being exercised in Vishakha, for the purpose, it's far different from the power being exercised in road safety case, the common cause case right now. So this is my observation, that because the need of the hour was different and the resources, the legislative material available was different in both the cases, exhibiting judicial activism in Vishaka was purely justified. And here the court is taking a very grounded stand, a very significant stand, that it is upkeeping the virtue of separation of power, and it is also expressing that judicial restraint, judicial activism cannot be exercised without acknowledging anything. It cannot be, it should be used sparingly, it should be used with due considerations, right? So this is for the case of common cause versus Union of India, as decided in the 2008 judgment. I hope this was useful to you. So if there is one question on judicial activism, you may draw a parallel from Vishaka and this case, because they are coming on a parallel for justifying the judicial activism or judicial restraint that maybe, maybe asked sometime in your exam, even if you are sitting for judiciary or even if you are sitting for an AOR exam. This one question can be a very prominent question that could be asked. So this is for the discussion. I hope this was useful for you. Thank you everyone, have a nice day.